Good morning, Ms. Clymer.
Good morning. Sarah Clymer for the defendant, Amari Gautreaux. And if there's no objection, I will address the issues as they were presented in my brief. There's a threshold question here that I feel that the court must answer, which is whether or not the Vienna Convention on Consular Relations creates a right, an individually enforceable right. And the Commonwealth suggests, because the courts have done so in the past, that they can resolve the case without deciding that question. But in this case is different because in those cases, almost all of them, if not all of them, the defendants were asking for the remedy of suppression, which the courts unanimously decided, regardless of whether there was a right created in the VCCR or not, that suppression is, that it wasn't a fundamental right, and suppression is reserved for the violation of a fundamental right.
Well, we know there's a treaty.
That's
we
right.
know there's a treaty, and we know there's a violation.
That's right.
Right? And so what is it that you suggest our obligation is in those circumstances?
To enforce the right. The
And what does that mean?
Well, you have to, the court, I believe, has to ensure that defendants are, or detainees, whatever the case is, are receiving that right.
Well, what does the International Court of Justice say should happen if the right is not afforded in a timely fashion?
The International Court of Justice has left it to the states. They've said, or to the United States, to come up with a remedy that they see fit.
Why is the remedy? What remedy are you asking for? You're asking us to say that a plea should not be valid unless Article 3 has been complied with?
Yes.
How does the absence of this information affect his plea?
Well, what the consulate would or could have done, presumably at a minimum, they would have given him some information on the deportation, which was in this case was his primary concern.
Well, it's all very speculative. He doesn't have an affidavit from the consulate saying what they would do, what their procedure is when they're notified, or anything like that.
No, that's true. He doesn't have that. I don't know that a consulate would.
Well, in this case, let's assume. Let's not assume. He was appointed counsel.
That's true.
Immigration consequences were discussed with counsel. He was informed at the time of his plea that the plea could have very specific immigration consequences in accord with statutory requirements. So what else could the consulate do?
Well, he was.
Or would they do?
Well, he was misinformed about the immigration consequences. His understanding was that if he were to get less than a year, it would not be an aggravated felony.
And that may be an ineffective assistance of counsel claim, and that's a remedy. I should get a new trial, or I should be able to withdraw my plea because I was supposed to get effective assistance. This was supposed to be what I was informed about, and I didn't get it. So that's a remedy.
And that is true. And we may have brought that and may still bring that at the time that the defendant submitted his motion. Padilla via Kentucky had not been decided, which may have had an effect on whether to bring the ineffective assistance of counsel.
Is there any other nation in the world who is a signatory to this treaty who has said that a plea that is done without compliance with Article 36 is invalid?
I am not aware of any. I'm not aware of that issue has been presented. The majority, if not all of them, have been issues of suppression or the dismissal of an indictment.
Right, and the U.S. Supreme Court has said, I think in Sanchez, listen, as far as we know, no other signatory has said that suppression is required, so why should we interpret the treaty to say that suppression is required, especially when the treaty doesn't provide for any remedies?
Well, the defendant's not asking for suppression here.
Well,
so
I know, but the argument is that basically none of the other signatories are doing what you ask us to do, so why should we be the first? Why is that required by a treaty if nobody else seems to think it is?
Well, I think that as a public policy matter, for one, is that if the United States expects this right for other signatories to enforce this right, which I would think that we would hope would happen if one of our citizens were over there, we need to enforce the right. We need to find that there is a right.
Well, the ICJ, International Court of Justice, has spoken on this issue specifically with respect to the United States.
Right.
Correct? So I don't know what's happening in other countries, but at a minimum, I think the court has said you need to provide a remedy of, you decide what it is, but it should be, in essence, a review and reconsideration of the case in some forum to determine whether there's been a serious prejudice. And then, consistent with state law, do something, perhaps. But, isn't the remedy a reconsideration and review to determine whether there has been some significant prejudice here?
I suppose, but I don't know that prejudice is the question here. The question is whether he entered a voluntary plea. Similar to, under the right to effective assistance of counsel, there is a presumption that counsel is going to be of some benefit.
No, I understand that, but let's assume that you do Justice Cordy's review, and you say, well, in this Commonwealth, we provide counsel. So he had counsel.
Mm-hmm.
There is a remedy because if he claims his counsel is ineffective, he has an ineffective assistance of counsel claim. We do not have an affidavit, as Justice Cowan suggested, that says that it is the practice of the consular to inform defendants of their legal rights under Massachusetts law. And I would suggest to you, I think it would be difficult to obtain such an affidavit. But if you had a case, for example, where the consul had not been informed, the defendant did not know that he had a right to counsel, didn't understand the Miranda warnings that were given, and also was badly beaten up, which is often why you want your consular representative told, and that he confessed to something or other and that was entered in evidence, that might be such a case. That's not this case. Right?
Right.
So, in short, in this case, the Commonwealth of Massachusetts provides a whole slew of remedies for a defendant in your client's position, which he has not even exhausted.
You're referring to bringing an ineffective assistance of counsel?
Yes.
And the existence of the statute, the Massachusetts statute that requires that a defendant be advised of alien warnings at the time of a plea. I take it, do we know how many states have a comparable statute?
No, I don't know the answer to that question.
Also, I have a fact question. The defendant's affidavit states that he took and passed a first-level English language course in his freshman year. Now, what does that mean? Do we know how much English he understands?
Well, there's definitely a language barrier. This was, 2003, 7 years ago.
I don't think his attorney, I read what his attorney said, and his attorney never actually said that he couldn't communicate with the defendant in English. He said the defendant preferred to communicate in Spanish, but he never said he could not communicate with him in English.
No, he didn't say that. It's difficult, I guess, to get an affidavit from. I had difficulties getting the affidavit from defense counsel. So
well, maybe that's because defense counsel wrote what happened, which is that he preferred to communicate in Spanish. It seems to me that we don't have, on these facts, we don't have an indication that the defendant really doesn't understand English.
Well, I think if you look at the docket sheets and you look.
I know it says that he needs an interpreter,
Right.
but that happens all the time. That doesn't mean that somebody, given the facts that we have here, that he took and passed a first-level English language course as a freshman in high school, and We don't have anything from his lawyer saying he can't communicate in English.
Did he have an interpreter?
That's the issue.
No, nobody recalls, and there's no docket entry, and they don't keep records at the district court whether or not there was an interpreter present.
But again, isn't that an ineffective assistance of counsel claim? If there's a record that says he needs an interpreter and he's represented by counsel, I mean, it's very unlikely, surely, that any counsel would permit the proceedings to go forward, if, especially where alien warnings are going to be given, without an interpreter. What's his native language?
Spanish.
I mean, it's not as if, that's not one of the languages where it's impossible to get an interpreter.
No, I mean, one would hope that that is what actually happens.
No, one would hope that counsel would do counsel's job and not permit a proceeding to go forward. And so surely you need an affidavit from counsel saying, I recall this and there was no interpreter.
He did not, the judge, nobody recalled whether there was one or not. They said they just simply could not recall.
Can I ask you another fact question? There was a motion to suppress evidence which was allowed in part in one of these cases, right?
Right, because he couldn't understand Spanish.
Because the finding was that he did not adequately understand or was not adequately given his Miranda warnings in Spanish, something like that. Did he testify at that hearing? There's some suggestion he did, so
I actually am not sure if he did. To be honest, part of the reason I had difficulty communicating with the client with the language barrier. I could not get, again, the record was disposed of, so I don't have I, for some reason, think that he did not testify at that trial, or at that hearing, but
Now,
I'm not sure.
Okay.
You referenced the transcript of what Judge Brennan ruled, but I don't find it as part of the record.
The hearing, the motion?
Yeah.
On the
Right.
hearing on the motion. It
It's not
wasn't
part
in the
of our.
record.
It's not part of our record, and it was not in the clerk's office. So I know that it was cited by you, but
Well, I apologize for that, because
Can you send it?
Yes, I can.
did the judge in fact say? I think from what was reported in the briefs, the judge essentially said, "I took this plea. It's my practice that if I see that a defendant has any difficulty understanding it, it would be my practice to bring in an interpreter." Is that basically what he said?
Yeah, he did say that.
And why is his practice from the judge who presided over the plea not sufficient to warrant a finding that either the defendant was English speaking or that there was indeed an interpreter?
Well, I think that ideally the judge, that's a nice thought. I guess if you've been obviously been in the district courts and you've seen, they run them through like a cattle call. And the only time that judge, very likely, I sat there actually the morning of this hearing and watched. Do you understand? Yes. Did you talk to your lawyer? Yes.
Yeah, but he has to give a colloquy for a plea.
And he says the colloquy, and do you understand that? Yes. So how he could determine whether this defendant spoke English very well is really unlikely.
Okay,
What are you suggesting as an alternative?
Well, I think
It's not whether you speak English very well.
Well,
The
you have to be-
question is, do you understand it? And if somebody says, do you understand it? And the answer is yes, what is the judge supposed to do?
Well, I do believe that, they might have them repeat. Whether it's a practical, the
You're
courts
going to
are
ask
busy.
a defendant to testify in front of a judge, and the judge tests the defendant's linguistic.
You can ask the defendant what his understanding of the colloquy is. What did you understand that I just said? Because I believe that often the case is lawyers, as a matter of time, as a matter, they discuss it and they said, yeah, just say yes, just say yes. And I think that it's naive to think that doesn't happen.
But there's no affidavit from Mr. Carlson that he told his client just answer yes to all the questions. We don't know that that's the case. We don't know that it's a poor colloquy as opposed to one which asks for some discussion with the defendant.
And we don't know it was done in English.
That the colloquy was done in English?
But there was no
But that was
translator.
without a
no
translator.
interpreter.
No
Right.
interpreter.
Well, you're right. We don't know, and I would say, just as I argued in the brief, there's a presumption that if there's a docket sheet that the colloquy was given, that presumption, when there is no record, that presumption stands. That yes, a colloquy was given, whether anybody remembers, whether anybody was there. Since there's a entry on that docket sheet, I don't think. Maybe they need to change their docket sheets and say whether there's an interpreter there or not.
Do you know if in the year 2003 in the Lawrence District Court there was an interpreter on staff at the court, permanently assigned to that court or permanently assigned to that in the Superior Court?
My information, which I believe I had put in my affidavit, was that the court said that there are interpreters that float between the courtrooms.
Is that 2 interpreters or something floating between the sessions?
Yes, and so, and if there's a notation on the docket sheet, then they will use, they'll
Come in.
put one in there.
Can I just, one last question, I'm sorry, for me anyway. So your view is that if he had been given his consular rights as the convention requires, Article 36 requires, he would have received accurate advice as to the immigration consequences of a guilty plea. Is that your view, and is that why there's been prejudice here?
My view is that if he had been able to talk to the consulate, he may have gotten additional advice, and he may have been able to articulate better to his own attorney and pursued very strongly to understand exactly what when a deportation might happen. My understanding is that, his cellmates kind of told him, this is what you need to do, and he's like, okay, I just need to get a sentence. He should have been more forceful in learning.
Very good.
Thank you.
Thank you.
Good morning. May it please the court, Tara Blackman for the Commonwealth. This court should affirm the denial of the motion for new trial. First, because the Vienna Convention, vacatur of a guilty plea is not an appropriate remedy for a violation of the Vienna Convention.
Why not? Why not? If, in fact, let's assume for a moment that if he had been informed that he had a right to contact the consulate and that the police would facilitate that, and if the consulate was in the best position to say, look, these are the immigration consequences. We deal with these cases all the time. This is what will happen or is likely to happen, depending on how these criminal cases are disposed of. So you need to really, get a lawyer who can advise you more specifically on this. Because he didn't get that advice, he gets wrong advice. He pleads guilty and ends up being deported. I mean, isn't that prejudice? Isn't that exactly the kind of thing that consular contact would remedy?
Well, Your Honor, we don't know if consulate contact would remedy that. And in fact, the consular notification provision of the Vienna Convention does not provide for any core fundamental rights that are not already provided for, either by statute or constitutionally within Massachusetts. That is why the defendant is certainly entitled to effective assistance of counsel. Effective assistance of counsel, as is clear from now Padilla, that a counsel has a duty to provide a defendant with the immigration information with regard to his plea.
So your position is, yes, there is the Vienna Convention is out there, and I take it you probably concede it wasn't complied with in these circumstances.
Yes,
but
Your Honor.
there are already remedies in our law. The ability to bring a motion for a new trial, which Massachusetts very generously grants afterwards, and ineffective assistance of counsel claims because an individual in the defendant's position has the right to effective, accurate information about immigration consequences, and if he doesn't get it, then that's the remedy, ineffective assistance of counsel.
You're correct, Your Honor. Yes, a defendant can bring a Rule 30B motion at any time, and in fact, as my sister has pointed out in her argument today, and as she pointed out in a footnote of her brief, she may even pursue a Padilla claim in the future, and maybe there is some type of underlying Padilla claim here. However, whatever claim that might be, it was not before the trial court, and it's not before this court today. The only issue that's before this court today, or there are two rather, but one of the issues is the Vienna Convention, and the other is whether or not the defendant was provided an interpreter.
Do you think going forward that it would be, given the Vienna Convention and its adoption, and it's therefore, I would suggest, there's certainly a strong argument that it is the law of the land, and other courts have said so. Shouldn't this be on, let's just say, I don't know, the Miranda waiver form? In other words, shouldn't there be some, going forward, some indication on forms that are provided to a suspect who may turn into a defendant about, if you're not a citizen of the United States, you can contact your counsel?
That would perhaps be a good idea. It's certainly a good matter of public policy to be following the Vienna Convention. However, as this court is probably, I'm sure, is aware from Sanchez-Lamas and also from Medellin versus Texas, the United States withdrew from the optional protocol, which is the enforcement mechanism for the Vienna Convention in 2005. And even prior to that, when the Commonwealth was a member of the optional protocol does not. It just says that the International Court of Justice has jurisdiction over the Vienna Convention.
I understand that.
So are you suggesting we ignore it?
I'm not, Your Honor. I do think that it would be a good matter of public policy to put this on the Miranda form, but I don't think that it necessarily, and I think there may be an appropriate remedy, but I certainly don't think that it's vacatur of a guilty plea.
All right, in the Deemer case, which is a 2003 Appeals Court of Massachusetts case, I'm sure you're familiar with it.
Yes, Your Honor.
In a footnote, the court says, it is reassuring to read in the amicus brief filed by the Attorney General that steps are being undertaken to address this issue in the future, and that is the failure to advise individuals of their Article 36 rights. Has something happened since 2003 to reduce the possibility of this in Massachusetts?
I don't know if something has happened to reduce the possibility of this. I certainly do think that some steps certainly should and could be taken.
How about in your county? In your county, are police more aware of this? Has there been any training? Or court magistrates more aware of this? Has anything happened to ensure that when these rights are applicable, they are provided in some fashion?
Well, I believe that the police or somebody is being made aware of this, because even in the defendant himself states in his affidavit that he overheard someone saying the defendant, there was an oversight, and the defendant, I don't believe he was ever advised of his rights to consular notification. So I do believe that based on that, we can assume that police are notified of this, and that there are some steps being taken. Unfortunately, there are clearly some oversights, as what happened in this case, and the Commonwealth does not dispute that. What the Commonwealth does state is that there are other, that in itself is not sufficient to say that vacatur of a guilty plea is a proper remedy. It stands precisely on the same footing as suppression. Just like suppression, there are proper remedies within our statutory remedies, constitutional remedies within Massachusetts.
Well, ineffective assistance of counsel, assuming it was established and it resulted in a guilty plea, well, ineffective assistance of counsel would probably undo that guilty plea, right?
Yes, Your Honor. If it would
have made a difference.
Right.
Exactly, Your Honor. And in this case, we have no basis to believe that it would have. And also, we have no basis to believe that, in fact, the defense counsel, apart from the defendant's own affidavit, we have no basis to believe that the defense counsel did not take into consideration the immigration warnings, did not advise the defendant. The plea counsel makes no reference to what he advised the defendant of with respect to immigration warnings in his affidavit. And in fact, based on the sentence that the plea counsel structured for the defendants, that it can be assumed that he did take into consideration, he did have an eye toward immigration consequences.
Do we know whether any consul has ever been notified in Essex, or any county for that matter, that an alien from that particular country, from the consul's country, that the consul has been notified?
I don't know if any particular case in which the consulate has been notified. However, what I do know, what I stated before to Justice Cordy, is that in this case, even the police made reference to the fact that
in the 2008 arrest, I think there was
Yes.
some reference to a subsequent arrest as to whether or not this had been done.
Yes,
So the
Your
police had some sense that there was something they should have done.
Exactly. So I believe there's some sense of it, right? So that there's obligation, and the police do know of it. I don't know of any specific case that I can reference to you right now where it has been done.
Okay. If I can,
A very favorable sentence. One charge was dismissed, one was filed, and on the last one, I guess, one charge was reduced, and he only got a suspended sentence. So we got a very, very favorable resolution of his case, and then he waited 6 years before he brought the motion to vacate, which has created some of the problems here.
Yes, Your Honor, certainly, because that certainly with respect to at least the interpretership, that is precisely why we don't have the lapse of time, why we don't have a recording of the proceedings or anything of the sort. What we do have is the judge's statement of his customary practice at that time, and that brings us to the second issue, which is that the judge's customary practice, the statement of his customary practice at the time, was that if an interpreter was needed in this case, one would have been provided. And also what the docket sheets reflect is that one of the docket sheets does indicate that an interpreter was needed at the time, was needed, and the defendant pled guilty to all three of the charges at the same time. So clearly the court would have been aware, and also plea counsel who had discussions with the defendant would have been aware of the need for an interpreter if in fact one was provided. And that's all we can rest on when we don't have a recording of or anything of that sort. What we can rely upon is the docket sheets that we have, the green sheet that we have, which in this case the green sheet indicates that everything went in accordance with how it should. The immigration warnings were given. Everybody signed the green sheet, the defendant included, and the judge states that his customary practice was to ensure that a defendant, if an interpreter was needed, one was provided, and that's consistent with what my sister learned when she spoke with the clerk's office, which that there are two available interpreters in the courtroom at all times, and if one is needed, they rotate through the courtroom, and if one is needed, they will respond to the courtroom where he's needed.
now, if I can turn to that issue, do you agree that by statute a non-English speaker is entitled to an interpreter?
Of course, Your Honor.
And do you agree that if this defendant were a non-English speaker, and there's reason to think from at least the suppression hearing that he's not, that the failure to have an interpreter would mean that it was not a knowing and intelligent plea?
Yes, Your Honor.
So the issue really is whether or not here there was an interpreter or not, and whether or not we rely upon the judge's memory of his past practice to make that finding.
Yes, Your Honor. I'd say that's really, but we have the judge's memory of his past practice, and all we have from the defense, the plea counsel time saying he doesn't even recall if an interpreter was
Whose burden
present.
is it to establish that there was not an interpreter present?
Yes, Your Honor.
No, whose burden, I'm asking?
It would be his burden to bring forth some evidence that an interpreter was not provided, and then it would be for
His burden to bring forth some evidence, or does he have what is the standard? What type of a burden does he have here?
Well, I think that there's a presumption that an interpreter was provided and that everything went according to how it should. If the defendant brings some evidence forth to rebut that presumption, then the court can make a determination as to
Is it
whether
the
or not
Commonwealth's burden of proof at that point?
if the defendant has brought forth credible evidence, then the Commonwealth can bring forward other evidence to rebut that presumption.
Well, but here he provided an affidavit which said, "I got no interpreter."
Right.
So would that not then mean that the Commonwealth then has the burden of proving by a preponderance that he did?
Well, Your Honor, and I believe that the judge's customary practice of what he did would be at the time.
Okay, but we're talking about burden, though. I mean, once he makes that assertion, is the burden not the Commonwealth's to show that indeed it was an intelligent knowing plea and he had an interpreter, because he can't be intelligent knowing if you don't know what's being said?
Yes, Your Honor. I would say that would be the Commonwealth's burden at that point to bring forward some evidence or to have it in front of the judge who, for instance, with immigration or in terms of a colloquy or with immigration consequences, the Commonwealth will get an affidavit from the judge, the plea judge who was there stating his customary practice. Here we have the judge who was the plea judge stating that this is my customary practice. I made sure that an interpreter was provided.
If the defendant can't speak English, are these forms that are given to him, I'm familiar with the forms that are given when a guilty plea is undertaken, are they provided in Spanish also?
I don't know if they are. I don't think they're provided in Spanish also.
No,
but
I just mean as a routine matter, are they?
Right.
Are they?
I don't think. I don't think.
Let me ask you, when the defendant files an affidavit that he attaches to his motion saying that I did not get an interpreter, does that get him a hearing? Does he now have to get up on the witness stand and at least testify that he doesn't speak English? Or how does the affidavit get into evidence, or how does it trigger the Commonwealth's burden?
Well, the thing is the Commonwealth has to. The thing is that it doesn't necessarily by itself trigger the Commonwealth's burden. If the Commonwealth can say this is not credible evidence that the defendant was not given his, if the court finds that it's not in of itself credible evidence, why don't we have an affidavit from plea counsel?
But does the defendant have to get up and testify?
No, Your Honor. Because the judge can find it not credible without him testifying. For instance, in this case, the judge knows what his customary practice was at the time, and he knows that if an interpreter was needed, he sees the docket sheets that was presented to him at the time of the plea.
But there was a hearing in this case, wasn't there?
Yes, Your Honor, but it wasn't an evidentiary hearing.
It was not?
No, Your Honor. And also, I would like to point out that with respect to the interpreter issue, and I think when you asked me, Justice Gantz, if whether or not necessarily he needed an interpreter in this case, whether it's necessarily true, I don't think that it's absolutely clear that he did. I think that there is some ambiguity about that, and I think that's even seen in plea counsel's affidavit, where plea counsel himself says, look, I know the defendant preferred to communicate in Spanish, but that certainly doesn't indicate the defendant could not speak English. It's clear that he had been in this in the United States for several
14 years.
Yes. I mean, and so he had some English knowledge of the English language. Certainly, he had taken a course in English in high school. Clearly, there's some ambiguity as to whether or not he could even understand
But the problem you have is that non-English speaker is defined by statute to mean a person who cannot speak or understand or has difficulty in speaking or understand the English language. So it's not merely can he speak some. If he has difficulty, he's a non-English speaker and is entitled to an interpreter.
Well, Your Honor, I would say that really the only thing we have stating that he had difficulty is his own affidavit, because even
how about the Miranda finding?
We do have the order on this suppression.
Okay, thank you, Attorney Blackman.
This isn't a question, but it would be very helpful if you could arrange to have the transcript of that hearing between you.
Of course, Your Honor. Thank you.
Thank you. We'll take a 5-minute break.
Thank you.
All rise.